Yes.
Lordship, respondents hearing, they were engaged on part-time basis as sweeper and cleaner.
Sweepers?
Sweeper and cleaner. They, for 3 hours working in all working days, they have approached to this court on 3 occasions. First round of litigation, their prayer was this, that they have been working for many years and their services should be regularized.
Service should be regularized.
Regularized. Now, in the learned single judge,
What is the order of the learned single judge?
learned single judge has declined to grant the relief. Your Lordship will see paragraph 8, page 173.
173.
173. The writ petitioner on entering this engagement, therefore, were well aware about the nature of the employment and also as to whether they were to be eligible for regularization. In the backdrop of these facts, the appointment of the writ petitioner as part-time worker stands on a different plank altogether from the 26 regularly appointed persons referred thereto, and as such, no parity can be claimed by the writ petitioner.
See, where is the order of appointment?
Order of appointment, your Lordship will see. Your Lordship will see page 140.
140.
140.
Yes.
The following persons are hereby engaged purely on part-time sweeper cleaner for doing sweeping cleaning work as directed at a fixed rate of rupees 1500 per month. The working time is from 8 a.m. to 9:30 and 3 p.m. to 5:30 p.m. on all working day.
1.5 hours, here 2.5 hours.
1.5.
So totally working for 4 hours.
3 hours. 3 hours. Presently, they are paid 6,200.
3 hours.
3 hours.
Morning 1.5 hours, evening 2.5 hours. Put together, I think.
Now, presently, this was the at initial stage. Presently, they are working 3 hours in the morning itself. Learned single judge, your Lordship, has declined to grant any relief to the writ petitioner.
Because you are a temporary employee.
I am aggrieved with the observations made in paragraph 11 and 12. Having declined the relief, the learned single judge made certain observations. At para 11, strangely, on the last affidavit dated 1/3/2024, filed by the respondent corporation at Annexure A to the said affidavit, persons have been shown to be appointed by the appointment order dated so-and-so as sweeper in the regular post. The stand of the respondent corporation, which is contradictory and misleading, is therefore depreciated by this court. It is therefore not expected from a public sector undertaking which is regarded as a model employer to adopt such double standard. Though this court refrains at this stage from imposing any cost, it is expected that in any such matter there should be a level playing field and persons eligible.
The respondent. Respondent.
Response to your lordship, I have served the copy. And paragraph 12, your lordship.
It's also the Electricity Board, Northeastern Electricity Power Corporation.
Yes, lordship. The relief which has been denied.
Of India. Who's the lawyer for Union of India?
Union of India, your lordship, is not.
So it's coming up for admission.
Lordship.
So the other side is there, we can ask them. Here, nobody is here. Union of India. You're also representing, you used to represent.
Lordship, he is here, he is on his legs in number 2, Lordship.
Dr. Mosika.
Dr. Mojika,
Your lordship, may have a look on paragraph 12.
See the order.
With the permission,
Where is the order of the learned single judge?
your lordship, I may.
Where is the order of the learned single judge, sir?
Learned single judge order, your lordship, is at page.
167.
Yes, lordship. 168. Start from 167.
Who are all the respondents here?
They are the sweepers and.
Who are all the respondents here in the appeal, sir?
Respondents are, your lordship, the sweepers and cleaner, 14 in number. They were the writ petitioner. I may just read your lordship paragraph
1
12.
minute, sir. So Northeastern Electrical Corporation is before this court.
Yes, lordship. As an appellant. As an appellant.
You are
We were the
appealing for writ petitioner.
No, we were the respondents in the writ petitions,
Sir, you are appearing for the corporation, correct?
lordship.
Yes. See, though the learned judge observation in para number 11
Yes, lordship.
gives relief only with regard to payment of minimum wages, etc.
Lordship.
The fact that they have been employed in regular posts for years together,
Lordship.
as a model employer, should you not regularize the services? How long they have been working?
Lordship, they have been working for quite some time. There is no denial of the fact, but they want regularizations, your lordship.
Yes, they are entitled.
No, your lordship will see
See,
that.
what is the ground on which they are, according to you, they are not entitled to? Uma Devi's case.
Uma Devi case, your lordship.
When did you,
Uma
when did
Devi
you
case,
employ them? When did you employ them first?
they were employed from 1985 to 2008. In between, starting from 1995 to 2008, on different dates.
2008.
On different dates, not that all the persons were appointed on the same day.
See, even
And your lordship, there is no requirement of the full-time.
Uma Devi, the Supreme Court in Uma Devi's case says that don't have a backdoor entry.
Yes, lordship.
If you read para 43 and 53,
Yes, lordship.
Supreme Court has given relief that if person has worked for 10 years, give them one-time exemption.
Provided the appointment is on the regular sanction post.
These are not working in regular sanction post. That is
No,
why
your lordship, they are against no sanction post. There is no sanction post. In one of the writ proceedings, even this court directed to explore the feasibility of creating the post. Matter was taken up, but that was not agreed to. And they are only working as a part-time, means they are outsources employment, your lordship. And in almost many offices, your lordship, this sweeping work, they come in the morning, clean the bathroom and go. And they are free to work in any other organizations.
So, see, only thing is, if they are able to establish that they have been working continuously and 8 hours a day, then we'll grant them relief. Otherwise, they'll have to raise an industrial dispute before the appropriate.
Yes, Your Lordship, there was no pleading that they are willing to work for.
No, they are working.
They are working for 3 hours only.
Don't disengage them.
We are not going to disengage them so far this 3 hours working is concerned. But we don't require them for a.
Then we'll consider. Admit notice. When during the course of the argument, the counsel appearing, senior counsel appearing for the corporation would submit that these employees were working for 3 hours a day or working even as on date 3 hours a day, and that all these persons have not been engaged in a sanctioned post. Full stop. The senior advocate fairly submitted that these persons have been working for several years, but as a part-time employees, and that unless a sanctioned post exists, the services cannot be regularized. He would further submit that there is a disputed question of fact involved and that the same could not be agitated in a writ petition. And the order of the learned single judge in granting relief is not correct. Taking note of the submission that the existing persons will not be disturbed and will be given job for a period of 3 hours till the disposal of the writ appeal, we order notice returnable by so and so date. Private notice is also permitted. But Umadevi case is against you.
Lordship,
paragraph 53, 43 and 53.
Your Lordship, paragraph 53, Your Lordship, if the appointment is in accordance with the rules. Here the appointment is not in.
You have given a go by to the rules. You want employment. You want the engagement to. You want workers to work, and you are giving a go by to the rules and to Umadevi's case and continue them employment. And coming back and coming to the court and say and trying to take shelter on the Umadevi case, we don't agree. The number of judgments.
Right.
Only way to avoid backward entry is take disciplinary action against the officer who appointed them.
Your Lordship, there is.
Automatically it will be over. We will hear you in detail.
Highly.
The private notice is also permitted. Yes. Coming up for admission.
Your Lordship, on the last occasion, the state is supposed to obtain instruction, Your Lordship.
Did you have your breakfast?
Yes, Your Lordship.
I am not able to hear you.
Okay, Your Lordship.
Yes.
On the last day, the state is supposed to obtain instruction. Obtain instruction.
Appeal?
The state is supposed to obtain the instruction, Your Lordship.
It is supposed to obtain.
It has got a. Yes. Oh, this is the matter which came up last time. 2012 joined
Yes, Your Lordship.
and dismissed in 2020, 8 years of service.
Yes, Your Lordship.
Not 28
I
years.
think this is the case.
No, Lordship.
Amjad Khan.
Lordship is.
Sir, I have written the notes, sir, based on the argument. It's at 8 years of service.
Lordship, yes.
Last time, see, AAG is expected to ascertain as to whether there is possibility of paying some compensation in lieu of reinstatement, as we are of the view that the reinstatement is not possible in the absence of disciplinary proceedings.
Lordship, may it please your Lordship. If
It's
Lordship,
not correct. However, the entire service benefits are for the actual services rendered. The draft order is there, last time order. over the entire service benefit for the actual service rendered for nearly 9 years should not be deprived.
Lordship, I'm awaiting that instruction. I don't know whether the department is agreeable or not. Lordship, let the matter come after 2 weeks, then I'll inform your Lordship accordingly.
What is the duty? What is the nature of duty?
9.
What is the misconduct committed by him? What matter? Madam, this is not the way to do it. Sorry. See, last time somebody argued,
Yes, Your Lordship.
and this coming for the second time,
Yes, Your
you must
Lordship.
have come prepared. You are before the first bench.
Yes,
I have been repeatedly informing, sitting with my brother judges. I sat with all the 3 judges, and every time I've been informing the bar. Otherwise, this bench is going to be very strict. We will be imposing cost. Yesterday I said we will impose cost.
no, Your Lordship.
Impose cost on the senior. The cost should be paid to the junior, not allowing the juniors to read.
No, Your Lordship, because due to because the conducting counsel who is arguing this matter is not well today, Your Lordship.
Because you are an instructing counsel, you must be prepared.
Yes, Your Lordship.
What's the matter? You get instructions.
Lordship, let it come after 2
Get
weeks.
instructions, sir. Because you have rendered 9 years of service, you don't want a reinstatement. Otherwise, we will have to set aside. How can I disengage an employee without disciplinary proceedings?
Lordship, there is, Your Lordship, ADP. He did not appear, Your Lordship. He did not appear. And he was fit to resume the duty, Your Lordship, but still he did not join. So there is a willful absence on the part of the red appellant, Your Lordship.
Remember this. You, for the 9 years, working days are less. Absence is more.
Lordship is not that the first time he was.
Sir, I remember this case. I think we remember that last time we said for the services rendered, you pay gratuity and other terminal benefits. He is not going to get any pensionary benefit because he has not rendered 10 years of service.
Lordship, let me have that instruction. I don't know whether the department is agreeable or not, Your Lordship. I'll have that instruction, Your Lordship. I'll inform Your Lordship accordingly on the next year.
Next time we must be, those who want to represent here, they must know the facts.
Yes, Your Lordship.
So it will come after 2 weeks, Your Lordship.
2 weeks.
Lordship. Oblige, Lordship.
46 days. Yes. Rule 8, 25 kilometers.
Malad.
25 kilometers.
Malad.
Yes.
That was the main issue. May it please your Lordship. Your Lordship, we have received some instructions. Lordship, small brief background. This rule came into existence in 2017. The rule 8, which says it has to
Find
be.
your report.
Lordship, we had filed a detailed report. We have received some more instructions. Lordship, we want to.
Want to file some? Want to file?
Some, Lordship. But Lord, besides that, there is some development, Your Lordship. Government is contemplating of moving the central government for exemption of that rule 8.
That you take.
Lordship, so I thought just apply the court. We have got latest instruction as to what the steps have been taken. Not that we want to take.
File, thereafter we'll pass orders.
Lordship. Okay.
Mr. Khan, Additional Advocate General, submitted that he's got instruction to state that state government is taking steps that state government taking steps to ensure that Rule 8
Lordship.
may not be applicable.
Not may not be. We are contemplating for exemption, Lordship.
So state government is taking steps, contemplating exemption,
Since our state is very small, Lordship, we have got logistic issue.
contemplating exemption of provision Rule 8, Rule 8, on short time, and you would file the status report as on date, the next date of hearing.
Lordship.
What's the matter? After? Week.
Lordship, 3 weeks? After 3 weeks?
Yes, yes. We posted in the month of, sometime in the last week of June.
Obliged.
Last week of June or first week of July?
Obliged.
Let's item number 1.
This civil court has no jurisdiction. Where is the original order? Original order, original order. He has to go to ESA. It should be civil court. See, in para number 4, there is a typographical error.
Lordship.
The observation made by the learned single judge that the employer has to approach the ESA court. The employer has got to approach the civil court may not be correct.
Lordship.
So there is a typographical error. For that purpose only we have posted it.
To be
We'll give the
Lordship. Lordship.
Here only it has got to be changed. Not wherever it is, don't change. Then we will amend the act also if you make it. So here only we have to change. It should be civil. This alone. Yes. He has to approach the civil court. May not be correct. Yes.
Lordship.
Further
All right.
conditions. Yes.
May submit, Your Lordship. There are some error also, Your Lordship, instead of because the ESI Corporation has filed this appeal, Your Lordship.
What is it?
The ESIs have filed the appeal, Your Lordship.
Where?
The present appeal
Present appeal has been?
filed by the ESI.
Correct.
Yes, Your Lordship. There is some error, Your Lordship, not the employer.
Not the. Where is it?
I think you should do that. So, no, I'm sorry.
Para number 1, Your
One
Lordship.
minute. Para number?
Number 1, Your Lordship.
Lordship, yes.
I told it a bit.
Oh, yes. Yes, yes.
I have a photograph.
The Revenue Council for ESIC submitted that para numbers 1 and 4 of the judgment is wrongly mentioned as employer instead of ESIC and ESI court instead of civil court. Correct?
Yes, Your Lordship. And para number 2, Your Lordship, it should be counsel for the appellant, Your Lordship.
Huh?
And para number 2 should be learned counsel for the appellant.
Order. Yes, why so much mistake?
What is correct?
Appellant is ESIC.
Yes, madam.
Where's the file?
Whoever submits doesn't matter.
But the submission is not respondent side. That is submission is not respondent.
Submission was made by the respondent.
Mr. Dev was appearing on that day.
They were appearing,
Yes.
they said that the respondent has contended that in terms of section 75(3), ESA code, whoever says is a ESA code of no jurisdiction. Nothing wrong with that. Ultimately, ESA code alone has got jurisdiction, sir. Correct?
Lordship.
That's all. This is not. Yes.
I was taken notice of the submission.
Exactly. The two errors will be corrected.
So we was the respondent only. Yeah.
Yes.
Maybe was asking me some